Okay, good evening and welcome to this evening's meeting of the Woodbury County Zoning Commission. Today's date is March 24th, 2025, and the time is 5 p.m. Tonight's meeting will be audio taped and the minutes will be prepared. In respect to all parties, we ask those present turn off cell phones or set to vibrate. Those in attendance are asked to legibly complete the attendance sheet upon the front table. I would like to take a moment to review the procedures that the commission will follow tonight. First, the commission will handle the normal housekeeping agenda items. Then for each application on the agenda, I will open the public hearing on the item. The planning and zoning staff will then present the staff report, including the staff recommendation. Any letters or other communication received from the public prior to the hearing will be entered into the record. The applicant will then have the opportunity to present his or her case and respond to the staff report. Next, we will hear comments from the public. If you would like to speak either in support of or against the application, you must come to the microphone. Please first state your name and address for the record. All interested parties shall be heard, but repetitious comments should be avoided. Repetitious or irrelevant comments may be ruled out of order by the chair. I ask that you remain respectful and courteous with your comments at all times. Please limit your comments to 3 minutes. After all public comments have been heard, the staff and applicant may make a closing statement. The hearing shall then be closed by motion and vote. Thereafter, no further comments from the staff, public, or applicant may be heard unless asked for by the commission. The commission shall then deliberate the case and ask questions of the applicant, the staff, or any party offering testimony. However, such questions do not reopen the hearing for additional comments from the public unless so requested or approved by the commission. The commission will then formulate and vote on a motion. Motion will either typically grant or deny the requested application. Any commission member who has an ex parte communication to place in the record of this meeting should do so prior to the beginning of the deliberation of the respective agenda item. That being said, let the record reflect that we have all commissioners here tonight. And then we'll move on to item number 3 on the agenda, which is public comment on matters not on the agenda, strictly informational. Not seeing or hearing anyone, we're going to move on to item number 4, which is the approval of the minutes from the previous meeting of February 24th, 2025.
I'll approve.
We have a motion to approve. Could I get a second?
Second.
All in favor, say aye.
Aye.
All opposed, same sign. Okay, the minutes have been approved. The next item on the agenda is a public hearing, which is an action item for the consideration of nuclear energy facilities and nuclear waste storage to be included as part of the Woodbury County zoning ordinance. Dan, do you want to read that information into the record for us, please?
Yes, tonight's public hearing is a continuation of the conversation we've been having about the potential addition of nuclear energy facilities. And of course, nuclear waste storage has been added to the conversation. Basically, the hearing is meant to address public comments that we can glean and receive from the public about the potential permitting of these facilities, nuclear energy facilities, waste storage, and of course, looking at potential concepts of the energy generation, maybe sub-concepts of modular, nuclear, and other technologies. Any type of recommendation that's fashioned toward the Board of Supervisors would have elements of addressing various aspects on the zoning ordinance itself. I do want to bring up just some general background. As far as this debate, looking at the framework in terms of how we approach nuclear energy facilities. Last month, I looked at it through the lens of administrator interpretation when we look at electrical energy generation, not including wind, which is in section 3.03.3 or 4, of the ordinance. And then we look at hazardous waste material or chemical and gas bulk storage as another concept. And within the ordinance, we do have the ability to interpret specifically whether that is a valid conditional use. Woodbury County had our previous comprehensive plan was established in 2005. Of course, we're under the new one through 2040. The ordinance that came out of the 2005 comp plan that led to the 2008 ordinance looks to have facilitated electrical energy generation in the broad sense. So we're kind of in a situation of interpretation. And ultimately what that does is it puts the county in a position that anybody could file an application for a nuclear facility and bring it directly to the zoning commission. For example, so let's just say somebody hypothetically brought one and we bring it to the agenda in June of 2025. The application would come to the commission and immediately each of you would look through the criteria in the ordinance, which is in 2.02.9. And you recall the first prong in there states that a conditional use must be authorized in a zoning district and meet any specific conditions or standards. What that's basically asking you is if something is a valid conditional use or not. And so both staff and the commission and ultimately the Board of Adjustment would make a decision based upon that criteria of whether we can hold up an application or not. Looking at the regulatory apparatus of this is what this debate has been about significantly in terms of how do we handle those potential applications. Is Woodbury County in a position to have an apparatus to be able to permit these or not? Part of that application process is a potential applicant has to go through the Nuclear Regulatory Commission, and Iowa is considered what you call an agreement state, which the Nuclear Regulatory Commission oversees the entire permitting at the federal level as far as these type of facilities and sites. So ultimately, an application would have to go through these projects through the Regulatory Commission. I had checked with the state of Iowa asking first the DNR about their permitting apparatus, and the DNR pushed me to public health. They talked about more of the low intensity type of new energy materials or nuclear materials that much was referenced as materials that kind of come out of hospitals. So like low grade materials have some level of regulation at the state level, but the high intensity grade definitely goes through the Nuclear Regulatory Commission. In fact, the individual who I had talked to, and you would see reflected in the emails that were sent, basically pointed me to the nrc.gov website. And you go up and click on the tabs, it's a very information intricate website that kind of decision trees you through the situations that you're looking at as far as nuclear, but they pointed that heavily to the NRC. And so looking at the big picture, we kind of got a couple things kind of going on at the same time. Going through the county attorney's office, the county attorney, Joshua Widman, who does a lot of our reviews, had kind of pointed out that it's better to have substantiation or definition on what a concept is. Electrical energy generation is very broad in nature, and chemical and gas bulk storage, we know that's broad, and then you're trying to some way tie that into nuclear storage in some way. And so what was included in the packet was a potential to include some level of definition or some concept that would show the ability to look at the land use summary table and be able to have a direct permitting mechanism much more specific to nuclear energy facilities and nuclear waste storage. So getting down to the specifics based on kind of attorney recommendation. Now, with that said, the other generally concept that we look at is all of our conditional use permits in Woodbury County are either at 500 feet from the project site, or except for concepts such as cell towers, what we've dealt with, and as well as airports and other aspects that are high as 1 mile. Looking at different levels of effects on emergency response, we've seen as high as 10 miles as far as responding to any potential problems as far as a plume or a notification area or anywhere kind of between 5 and 10 miles. And reason I bring that up is notifying a property owner about a conditional use is that request that we put in there about a certified abstract or listing. So right now for a nuclear facility, if we did it under electrical energy generation, it would be 500 feet from that site. And so it would be probably a prudent step to look at the notification zone of being anywhere up to even 10 miles, which was kind of presented in the packet as a way for the applicant to provide an abstract listing of who all the stakeholders are within that respective zone. Now, with that said, the Woodbury County fee schedule that is tied to zoning has the different prices that it costs to file a conditional use permit. And we, the supervisors, I believe in the fall of 22, passed some language that passed the costs on to the processing of letters. I believe it's any over 100. We typically try to have the fees sustain the notifications and the office printing and everything when we get a real basic conditional use permit apparatus. And we know if we're going to be notifying people potentially within 5 or 10 miles, that's going to end up being a major professional job from a professional institution to probably help us generate and kick out that many notifications if we were to look at potentially amending the notification zone on there. So logistically, we are in a scenario here, and I include basically much of what I say on page 10 of the packet in the staff analysis on what our conditional use permit apparatus is as far as an application landing here and ultimately going through the zoning commission to the Board of Adjustment and deciding on what the relevant facts of the case are, and ultimately hypothetically deciding project by project based on what the ultimate conditions are for potential developers as we look at any type of conditional use permit scenario beyond nuclear. So based upon what I gleaned from the county attorney's office, and of course adding to, and again, the interpretation is that we do have room in there where it says general industrial conditional use. It's prohibited in every other district. So there is a standard there that Woodbury is open to a level of nuclear permitting as a conditional use by virtue of those two items that are highlighted in there. It's just we're at a juncture where we could make a decision on deciding more specificity as far as that level of permitting. So that's my general introduction. There is kind of a general ordinance in there if that's a path that the commission might want to consider to the supervisors as a form of recommendation. But I would caution that if we want to look at the notification zone as well as the definitions or the specific criteria, that would be essential. Depending on what the commission decides, it would be highly recommended to require sending the decision concept to the county attorney's office for vetting of definitions that are placed together. It's the county, this is sort of like a maiden voyage, this concept, as far as not being a lot of Iowa counties that had directly taken up nuclear. So much of the definitions have been kind of pieced together, not copied from another ordinance, but pieced together from like the Nuclear Regulatory Commission to understand a bit more about what nuclear fission and fusion, which you would see those concepts laid out. So I'm going to go ahead and kind of pause there. Of course, we're at the public hearing as Chairperson Zelmer Zant had mentioned, and we do have last month Mr. Stephen Curtis is with us again tonight here over the phone, and I would probably ask that we give him a few minutes to maybe 5 or 10 minutes to describe to us a bit more about what the nuclear waste storage is and what the ultimately kind of what the expectations are from a hypothetical standpoint. I do want to be clear that this is focused on the regulatory aspect, on what counties should be concerned with in that regard. But I would definitely ask Steve, if you would kindly introduce yourself again, give us your background, tell us kind of what your initiatives are a bit, and help us define what nuclear waste is and its relevance, as well as nuclear energy facilities. So if you could kind of piece that together in 5 to 10 or so minutes, that would be wonderful. And we do have him on video. So for the audience, I'm going to push him over here and have him introduce himself. And Steve, I guess we'll turn it over to you.
Thank you, Dan, and thank you, audience. My name is Steve Curtis. Like you said, my background is I'm a health physicist, which means I study how radiation affects people, radiation safety, that sort of thing. My background relevant to this is I was 14 years in the Department of Energy at the Nevada site office, where they actually, when I first went there, they were testing atomic bombs. Very soon after I arrived there, they quit. I went into a nuclear emergency management. You may have heard of the NEST teams, Nuclear Emergency Search and Consequence Management teams, where I was a technical team leader for some lab people who would go out on deployments in case anything, if they wanted to find a point source or they wanted to find a deposition that happened. Those are the teams that would respond. So I did that for about 15 years. That's my relevant background to this. And of course, my background in health physics helps me understand the radiation safety part of it. I think that Dan wanted me to talk a little bit about the fuel cycle for a nuclear power reactor. And we have right now in operation in the United States something called light water reactors. You have one in Iowa called Duane Arnold. And so I'm sure you're all familiar with that. But some things people don't really understand sometimes. So let me basically quickly go over this. When fuel comes into the reactor, it's enriched in an isotope of uranium called uranium-235, which is the part that fissions. So to do that, you have to mine and refine uranium. Then you have to put it through something called not gaseous diffusion, centrifuge. Centrifuge, where you turn it into a gas, spin it, and then you take the lighter stuff off, which is uranium-235, until you've enriched it to about 3 or 4%. Then you turn it back into an oxide, make it into a fuel pellet, put a bunch of fuel pellets in an assembly that's about 12 to 15 feet tall, depending on the design of the reactor. And that's the fuel you use to create your fissions and create your energy by heating up water and turning it to steam and turning a turbine to create electricity. So that part works well for about 3 years. And then the fissile part, the U-235, burns down from about 3 or 4% down to about 1%. And at the end of that period of time, about 3% of the material turns into fission products. So when you fission a uranium atom, you produce 2 pieces of smaller atoms and about between 2 and 3 neutrons. It depends on whatever the process is different, but it's always between 2 and 3 neutrons. Those neutrons can go on to fission other atoms of uranium-235, and that's how you sustain the chain reaction. So when you get done with that, that's, like I said, about 1% of uranium-235 is left. And 95% of the uranium doesn't even change. That's the uranium-238 that doesn't fission. And you have about, like I said, 3% of those fission products, and the rest of it is higher level atoms larger than uranium. They're called transuranics. They include mostly they're plutonium, but there's other higher level ones like curium and einsteinium and things like that that are produced during the process of the fission. So when you take that out, the fission products are extremely active radioactively. They're high levels of radiation. So once you take it out of the reactor, you have to handle it all remotely. What happens now is it goes into a pool that's about 30 feet deep, and that's enough to stop all the radiation. It's enough, if they circulate the water, to take off the heat. of the decay products. This is all heat of radiation atoms decaying, the fission products mostly. So after about 3 years, 3 to 5 years, depending on what the burnup is, that's now cool enough that it can go into what they call dry cask storage. It's cool enough that it can air dry. It doesn't need the water to dry it. So at that point, ideally, that the spent fuel would have been taken by the U.S. government and buried, but there's no place to bury it now. That's one of the problems we're going to talk about a little bit. So those go now into something called dry cask storage. So the reinforced concrete containers that sit on the reactor site and basically air cool the fuel until somebody decides something else to do with it. And that's where it sits today. So we're looking at a situation where this stuff is very, very safely stored. But what most people don't realize, this stuff is very, very, very valuable, because the rest of that 95%, actually 97%, because you can fission the rest of the U-235 and the transuranics, can make electricity if you put it into a fast reactor and recycle it. That's what we advocate. So what we're looking at is a process where you could, as a state, decide to accept this stuff. You'd be doing the country a very great favor, because nobody else will right now. And the situation is that as long as that part of the nuclear power industry is not handled, generally the public does not believe that that's a good situation. They want that stuff disposed of. So what we are going to advocate is that Iowa would consent to accept that. Now, why would you do that? First of all, like I said, there's 30 times more energy in each of these in this material than there was the whole time that it burns. So if you got a gigawatt reactor, then you can take 30 times that energy back out of it if you put it in a fast reactor over time, and that's quite valuable, as you might suspect. Around the whole country, there's 90,000 metric tons of this. It's got a potential to run about 270 years of the current U.S. Demand of electricity right now. And we all know that the energy demand is going to be going up. So there's a reason to really consider this. And if you do, you will be the first state to do so. And the first state to get this going may be the one that runs the clean energy future of the United States and indeed the world, because a lot of the places in the world have the same situation. So question is, do you bury it, which we're not even close to being able to get permission to bury it, or do you want to make energy if that's the question? Now, they do have a concept of interim storage facility. New Mexico and Texas are first in line for that. In fact, they have approved plans for that, but both of them are fighting that. They don't want the spent fuel in their states. Neither one of them does, just like Nevada fought it for Yucca Mountain. So there it sits, no solution. You could provide a solution. So the idea is that if you open up the stage for that, there could be quite a large business proposition for Iowa. And you probably understand more about this now than about 98 or 99% of all Americans do. And the process is to get this information, get people to understand it. And of course, I'm sure you have lots of questions, but my 10 minutes is up, and I think I gave you a very good background of what we're looking at. Does that sound good, Dan?
Yeah, absolutely. Would the commission have some questions or?
Thank you, Steve. I
Yes.
have further questions on
Great,
information. We have another commissioner that does.
perfect.
Hey, Steve, a question I have is are there no fast reactors that are working today that could use this spent fuel? What's the reason why it hasn't been approached at this point?
That's a very long, mostly political story. The fact is, we have had reactors of this design running, and one ran for 30 years experimentally in the Idaho desert and worked very well. But the basic idea is that Rickover wanted light water reactors for his submarines. So when that happened, they abandoned this idea and went to the light water reactor concept. And that worked out well because they suddenly found a whole lot more uranium. Became cheaper to do the light water reactors and make them work. And they've worked very well for now almost 70 years. But now we have this spent fuel that we need to do something with. So the quick answer is there are about 8 or 9 companies out there, startup companies with technology that can do this. They need a license, number one. And so you have to go through the NRC to get a license, and there's a big backlog in the NRC, and they're not in what I would characterize as a real big hurry to get those licenses out. So that's a problem. It's holding up the industry. A state, I think, could influence that. So we're in the mold of very possible technologically kind of dicey politically. And so the reason we don't have those very, very shortly is that nobody can seem to get a license to do them. And there hasn't been a real strong commercial approach to that. So we got to bring it from the prototype stage into the commercial stage. And that's a proposition you could make to the US government, that you could do that in Iowa in exchange for some kind of compensation, which would be I would recommend you try to do it with private companies and then leverage the spent fuel fund, which is about $50 billion right now, to transfer that over to a private industry, which they're chomping at the bit to do. And if you came up with a solution, an agreeable solution that would fit their parameters of we've solved the problem, I think you'd find a very amenable federal government, especially now when they're looking more at states' rights and looking more at states' ability to do things and make their own way. So that's a long answer. I hope it answered your question, but like I said, most of it's a political situation.
I have one more question. Is there another country anywhere that has done this? Has it been done anywhere at this point using spent fuel?
Not using spent fuel. There are fast reactors operable in Russia. Okay, but the only place they've done it commercially is that reactor that ran for 30 years out in Idaho that they experimented with. Now, Argonne National Laboratory created this technology, and that's whose reactor lab it was when they were working on it. They're kind of miffed that it never went any farther than just that 30-year run to prove a concept. So no, not with spent fuel, they're not doing it now. And so you would have to get one of these companies licensed to create what we call a first of a kind reactor. And then you'd have to figure out how to change. It's simple conceptually. You change the spent fuel, you grind it up, and you change it into a chlorine or a fluorine, depending on what salt you use. And the design we like, you mix it right in with the coolant. And you can run that thing for about 60 years, and basically you just add more of this chlorinated spent fuel after you get it started. It takes some fissile material to get it started, but once it's started, it could run completely off of the spent fuel. Now the answer is no. There's nobody's doing that right now on a commercial basis. But like I said, Russia has fast reactors operating, but they use a more they don't use spent fuel. They use enriched fuel. It's of course easier because you have more neutrons to play with. But the idea is if you do use current fuel, you're making more spent fuel. You're not consuming the spent fuel. So you're not solving this issue. And I'm telling you what, there's a big need to solve it and give everybody at least the concept that there is a solution. So that's the answer, I think. Did I answer your question?
Yeah, thank you. I appreciate that.
Okay, great.
Steve, I got a question for you. By utilizing the spent fuel this way, do you then increase the level of nuclear waste down the road, or is it the same amount that you had to start with, or how does that impact come into play?
What it basically does is transmute it. They use transmute as a word that kind of means changes from one chemical form to another chemical form. And what you're basically doing with a fast reactor is the transuranics, the uranium, can both be fissioned. And then what you do is you set the neutron economy enough so that you can activate the uranium-238, turn it to plutonium-239, and then fission the plutonium-239. So that's the trick, is get enough neutrons that you can activate and burn. We used to call that breeder reactor. And they did run experimental breeder reactors that worked very well. And so you actually make more fuel as you produce it. The trick is you probably don't want to pile up any more plutonium for later use, for kind of past that. You want to make the plutonium just about as fast as you burn it up. And so that means you could keep the reactor going as long as the reactor physically can go. That's at least 60 years, but our reactors now are being approved out to 80 years, and the modern reactors are even safer and less complicated than the light water reactors. So the answer is that you can make this work, but you have to start at a kind of a prototype first of a kind stage, and that's what we're advocating.
Thanks.
Mhm.
Hello, Steve. My name's Kent, and I came in late. My shift didn't end until 5 o'clock. So sorry, I'm coming in at the tail end of your, of what you're informing everybody here. But
I understand that, my friend. I understand it well.
so, in Iowa, we value the farmland and our rivers, of course. And perhaps you said this, but what's the best way to store this?
Okay. Right now, it's being stored in concrete containers, and very, very safely and robustly so. Mainly because you have to shield it. It does give off a lot of radiation. But like I said, the water in the water pools is enough to shield it, and everything is done remotely, of course. And they take it out of the water, they put it in these concrete casks. One fuel assembly weighs about half a ton. They put 15 to 20, depending on the design, into a larger concrete cask that's very robust and well reinforced concrete is what it's made of, mainly so it shields the radiation, and it does it very, very well. But that's also a very strong container as well. And right now, that's where they're sitting on the spent fuel. At the end of the process, you just have more fission products, okay? So fission products are the things that are very radioactive, but they're the ones with the shorter half-lives. So when you worry about, I don't know, 10,000 years or a million years, whatever they're worried about, that goes away with fission products. At most, it's 300 years, they'll get back down to the level of natural uranium. But after about 100 years, they get down to a very low level and make them very manageable to use. Now, something interesting to know about fission products is most of them are rare earth elements, and they're also platinum metals like rhodium, ruthenium, things that are very, very valuable. And after about 50 or 60 years, you can mine those. Doesn't make any sense to mine them out of 3% fission products. But if they're all turned to fission products, that gives you a whole bunch more material that makes it a lot more sense to mine. So as it sits there for 50, 60 years, depending on how comfortable people are with using it, those materials can be separated and used as rare earth and very valuable metals. So there's, even in the fission products, there's not the end of the road for these things. They can be used in other ways. And like I said, after about 100 years, the level is very, very low on them. They decay exponentially. So they decay very quickly in the beginning. And as they go down, they slow down their decay process. And like I said, after 300 years, they reach the background of natural uranium. So they're much more practical to contain than they are than what they imagine for this spent fuel is now. The volume doesn't change that much. Okay, so the volume is pretty much the same. If you've heard of volume reduction, you've probably, what they're thinking of is separating out the uranium-238 I talked about, which could be treated as like low-level waste, and then only treat the rest of it, which takes the volume way down, for something they call spent fuel or high-level waste. High-level waste really deals with chemical reprocessing things that are left over. So this spent fuel is a high-level waste kind of category, but not the same as that. So that would reduce very much the volume of what you do. That's not what we're talking about. We're talking about fissioning everything and turning it into energy. So you'd have the fission products left almost exclusively, which like I said, are highly, highly radioactive, but we know how to deal with those very robustly. And the nice thing about a fast reactor is you don't have to shut down the reactor because the fission products are there. In a light water reactor, the neutrons are going slow, And so they have a real problem with some of the fission products taking away neutrons, absorbing neutrons. But in fast reactors, they don't do that. So your neutron economy goes way up. Plus in fast reactors, you get a few more neutrons out. So the neutron economy looks very, very good for fast reactors, much better than light water reactors if you're trying to breed and burn, because you need 2 neutrons to breed and then fission. Whereas fissile material, you only need 1 neutron to fission it. So that's the trick you play with physics, but it's those things are all solved. Now we're into the engineering stage and the production stage, and how do we make that practical commercial? Until somebody gives an incentive to do it, or at least gives them a license to do it, that's not going to happen. And that's the crux we are at today.
Thank you. Do we have anyone in the public that wants to speak to this matter? I think we have information. Yeah. And I think that's on our website, isn't it?
No, we can provide or distribute anything
Okay.
at request.
Okay.
If you could give me your email at the end, I can get something to you.
Okay.
Steve, I have one more question. At the end of the
Sure.
day, if we had one of these reactors up and we were using the spent fuel, would we be reducing the amount of that, when it's all said and done? Because besides, producing electricity, one of the motives in this whole technology is to try and find a way to reduce the amount of these spent fuel rods that are laying all over the country in these different plants. Is that also going to happen?
You kind of reduce the amount of material, you reduce the time you need to really protect the material, not necessarily the volume of it. Okay. Now it's a very small volume. I mean, there's spent fuel is a very, very compact and easily protected. In fact, it's probably the least imposing of any energy producing byproduct. It's all solid, it's all contained, none of it reaches the environment. And so it makes it very easy to deal with. But the volume, people have an idea that 90,000 tons is a huge volume, but really it could fit in a Walmart supercenter. All of we have could fit in a Walmart supercenter, that kind of size of a building right now. And it's not that tough to deal with. So reducing the volume is not all that big a deal, but reducing the time that you have to protect it, people are worried more about that than they are about. And then the cost of a buried repository is astronomical compared to the cost of translating this over to a private industry. To give you an idea, there's $50 billion in spent fuel fund. We could think we have a plan that could easily translate that over to a private industry with that amount of money. But just for one repository, they're looking at about 400 billion. And the feds don't even really have that. And that might be why they're delaying it. I don't know. But they want to do an interim facility. And I don't know why states aren't beating themselves out to get an interim facility. It's only 32 acres for half the spent fuel. And so if you've got 64 acres, you could take it all. And the government would pay for all the construction of the facility and love you for it, because now they have a solution that Texas and New Mexico are fighting them in court over. So it's not really the volume that's a concern. It's the time of storage that's really the concern. And well, we could go into this in great detail. We won't. A million years is a ridiculous amount of time. 10,000 years even is a ridiculous amount of time. But that's what they wanted to protect it for that length of time. And that reduces all this down to about 300 years, which significantly simplifies the engineering problem. I don't even think you need a deep repository for that, because you'd want to access it later if you wanted to use the material. So time is what we're looking for, not so much volume, because there's really not that much volume anyway.
Thank you.
Mhm.
I have one question for you. Can you tell me why Texas and New Mexico are against this?
Okay. Without disparaging anybody, I'll get into that a little bit. It's the same thing that happened in Nevada. Now, I lived in Nevada for 38 years, and I went to my first Yucca Mountain meeting in 1981, and those people were, through public information, were ripped into a very much a high fear of this stuff, for what I indicate is no good reason. Like I said, political reasons. So they fought very hard. In fact, still have a commission out there desperately every day fighting to keep it out of there because the law still says it's coming to Nevada. They never changed the law, but they're probably not because Nevada figured a way to stop it. Well, that scared all the other states. They scared them with transportation. They scared them with accidents. They scared them with all kinds of crazy things that really weren't, were kind of long-term shots that really, when you consider benefits versus risk, really didn't apply to much. But Nevada was able to stop it. Well, for the same way, they can, New Mexico and Texas can stop it through the political process and through the court process. But you're right. If I could get over there and talk to them, I think maybe I'd convince them to keep it. Because for if you invest 32 acres in each state, what's the harm? But they have strong, mostly fossil fuel interests, and then, well, in New Mexico, you're talking about Santa Fe, which is probably one of the top liberal capitals and populations of people. So they're very emotional about it, and they express that emotion as delaying tactics. And then Texas is big fossil fuel, and they're all worried about their Permian layers of fossil fuel being invaded by this interim storage facility. So they're fighting, and I'll be honest with you, the federal government isn't going about it very, very smartly either. They said they wanted to get consent for this to come out, and now they're fighting in court to force them to take it. That's not the idea. The idea is to convince them that they'd want to take it. And I, for the life of me, don't know why they wouldn't want to, but they don't. And I think it's mostly to do with the emotional fear factor that's been drummed up over this last 40 years. In fact, that's where you guys could have an advantage. If you weren't afraid of it and you wanted to pursue it, nobody else would fight you for it. And that's that there. I will tell you from my perspective as somebody who's studied this for many years and a health physicist, that there's really very little to be worried about. There's never been an accident with this stuff. The Navy ships it all the time. They move their reactors out from Newport News and Virginia Beach out to Idaho all the time. There's never a time when there's probably not a spent fuel cask on the railway somewhere going out to Idaho. So there's never been an accident, never been any kind of injury or anything from these things being shipped, and yet they wanted to create these big visions of trouble and danger. So people tend to be afraid. If people tell them to be afraid, they tend to be afraid. I can go into great more detail on that if you want to, but the reason is very emotional and very much a political position in both Texas and New Mexico to stop it. But no state will consent to accept it now after Nevada spent 30 years fighting it, because they went up to all over the states and talked to them about it and really spent a lot of effort and time and money to try to denigrate it. But the truth is different than the perception. Well, all truth to any person is perception. So you just got to create a different perspective to them so they can maybe see a different perception. That's what I'm trying to do. So the answer is practically and technically and even safety wise, there's no reason to fight it, but they're fighting it over a political and emotional principle that I, be honest with you, I don't understand.
Thank you.
Mhm.
Any other questions or comments on this matter? Public? No one's jumping up.
Wow.
Yeah, quiet night. Okay, so
Okay.
do we close the public hearing at this point?
Depends on if that's the commission wants to.
Do you want to close the public hearing at this time? Do you have more comments, questions, anything? Not, I entertain a motion.
A motion to close public hearing.
Second.
I'll second.
Okay, all in favor, say aye.
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 Thank you. Motion, you all against, say aye. Sorry, I'm assuming I heard everyone unanimously. Thank you. Okay, so we have information in front of us as what to do next. Commissioners, what's your wish?
Maybe just get some clarification with the attorneys. It looks like we need, maybe they're looking at having the correct framework on this, and they don't want to move ahead on any gray areas. They want to, looks like the attorneys want to make some clarification on a few things and maybe go with their advice.
If I may respond, yeah, the commission is kind of in a position to assess where this is at in the debate as a whole in terms of the recommendation that they ultimately craft to the supervisors. And so, like I kind of led off with, what I interacted with Joshua Widman on was, how do we have it defined? Technically, we could get an application tomorrow based on what the framework is, where the zoning commissioners and the Board of Adjustment members would be in the position of interpreting that as a conditional use. Now, that's not the most solid ground. What's to say, for example, you get back into the intent in 2008. That means a lot to lawyers, it seems, as far as looking at the intent of the county when we went through the comp plan, went through the development of what electrical energy generation is. And so maybe if somebody generally doesn't see, nuclear in a sense being part of that category, and we're looking at parsing and debating what it is in particular, maybe it's not as quite on solid ground if it's not defined specific in the ordinance. Our land use summary table has very broad categories in it. And typically they're broad because it gives the commissioners and the Board of Adjustment members flexibility to make the interpretation on a project by project basis. We do all sorts of things across the board in our table. There's been borrow pits brought to the commission. The commission generally knows what a borrow pit is. It's pretty easy to define what a borrow pit is. It's excavating, taking fill from the ground, being concerned about where it's being transported to another site. And so it's pretty reasonable to define. It's one of those things, you know it when you see it. Nuclear, on the other hand, as Mr. Curtis has defined, there's so many different facets to it. And we're looking at the storage. I know he had referenced fast track and the light water reactors and the different forms. The question is, how do you have a definition that, picks up directly on that, where somebody ultimately files with the NRC, because nuclear is still in the NRC hands as far as the ultimate regulatory to that. Now, let's say a company does a huge investment in it. They're going to want to know how the county itself would ultimately regulate that. They usually have what you call in zoning environmental specialists that study all the aspects of landing a permit or a project. They want to know what they're getting into before they bring the project up to the local level. They need to know what's going on at the federal level, the state level, so that they can reduce a number of surprises. At the federal level, there's a lot of money to be had in terms of investing in the project. Now, they're going to need to know generally what to expect at the local level. And the issue there is the level of uncertainty. When we look at the conditional use permit, we only know once we run it through the board proceedings, as far as getting input from the neighbors, getting input from the community directly, and seeing how they feel about how the project will fit ultimately in their neighborhood. We can look at it across the board as far as, okay, we're looking at an industrial zoning district. So typically industrial, you're going to have a lot of industrial assets within that region for sure. Something that is unique about Woodbury, and I think we have to always kind of keep this in mind, is our industrial still does have some housing in there, which is considered legal non-conforming or grandfathered, meaning that eventually if the use expires and folks stop living in the house or they sell it off, that use will eventually expire. But we still have, in terms of some proximity, especially up closer to the airport, There's some housing still involved in the county around there. So that increases at the ground zero the level of input that you're going to get from the direct neighbors, how they feel. But if we consider casting the net wider in terms for emergency purposes, if we're looking at 10 miles for a notification zone, we live here in a tri-state area where we have Nebraska, we have South Dakota, we have other counties that are definitely stakeholders in terms of what happens here. It's paramount that people know directly what is going on with that respective process. So when we look at the question of if somebody were to do an environmental type of study and look at Woodbury County as a whole, the question comes to the matter of, is our ordinance or our language stable enough for a company to consider the whole big picture of running it through the NRC? Now, if you're going to run it through the NRC, you're going to need to see that the local community has some reasonable landing pad where they're going to get a fair shake as far as the permitting level across the board. And I think that when the county attorney's office, Joshua, brought up the fact that you need to clearly define these things so that there's the level of expectation that when we're talking about a nuclear energy facility, that it's defined enough that if it's challenged in some sense in a court, that we do have a level of definition. Everybody knows anything at any time can be challenged in court. We know that. And as far as an administrator definition or an administrator interpretation is by far one of the weakest as far as versus something enumerated directly in the ordinance. It comes down to legalese debate. And so folks could challenge even on the merits of even being able to hear that application. In other words, let's say the Board of Adjustment went ahead and interpreted criteria number 1 as, okay, we can hear this and we can read it. Then we move into the next level of criteria. They're looking, we're looking really carefully at the public health, welfare, and safety specific to the neighborhood. I oftentimes highlight the fact that our conditional use permit is kind of designed in a way to put the burden on us to flush out the questions that we need to ask for the companies, et cetera. Now, many of the people that might be pursuing, let's just say hypothetically there's an application, they usually probably hire pretty good environmental specialists and reviewers to come in and look at our criteria and try to reduce the ambiguity. But a conditional use permit is still has a very big level of ambiguity going through. But the goal is once you get something through the NRC, that many of those questions would hopefully be flushed out. Because in reading the literature and some of the NRC regulations, I know that they talk about, some community efforts or recommended to host an event or bring publicity or attention to the potential project that is going on. We've seen some element of this in our recent history. I'll give an example of even the pipeline companies have put out different standardized, have an event down at the convention center that talks about easements or different things where they're meeting a certain level of trying to engage the public based on a criteria, basically following the federal standard at the minimum potentially. Now, coming back here again to Woodbury County, the question is our current conditional use permit infrastructure on solid ground in terms of if they look at this county as a site, maybe they would be comfortable enough with it, maybe or not. But as far as having direct language, it's always on the safer side to define a level of expectations as far as filing the respective permit. And so that kind of goes down to the very basic root of how I opened today and saying that we do have those two categories. That is electrical energy generation, not including wind. It's already in the ordinance as a C. And we've got chemical and gas bulk storage as a C. I know the county attorney's office found the first one a little bit more stable than the second one, because you're far more debating chemical compounds in the second one, and that can leave it up for debate much further. But anytime you leave even the definition of something up for debate, that means you got a little bit of a red flag to encounter, and that's where he's giving us the advice to be on the safe side as far as having a line item in the ordinance that would actually define these level of activities to an extent. This proposal that's in the backup material is not meant to even change whatsoever the zoning commission and the Board of Adjustment as a process. It's just meant to give the zoning commission and Board of Adjustment some more tools as far as the district, a 10-mile notification zone, as well as specific definitions that allow to hear the application. Passing or making an adjustment to this ordinance also doesn't mean that you might approve a project or not either. You might come in and potentially, maybe the application isn't up to the standards or maybe not meet a criteria. However, because of the level of investment in this, it's probably very imperative that companies kind of get that stuff figured out. So that's always the challenge with a conditional use. When people with the most basic projects or the most basic conditional uses come to the office, the goal is to try to make it as turnkey as possible through an application. But we've all learned, even in recent past, that some conditional use permits may not necessarily be meant for that neighborhood or that area. And so zoning commissioners and Board of Adjustment members always have to be equipped to be able to say no as well as yes. They have to be objective. They have to be able to have the tools at hand to make the full scrutiny across the board. So that's what the challenge part is. Heavy investment, at the same time, level of permitting and what the expectations are. And that's why those companies do pay environmental folks to assess areas, to assess neighborhoods, to figure out whether their project has a reasonable striking chance. One of the things in the zoning office that I always like to encourage applicants to do is try to challenge me. Tell me how my viewpoint or my interpretation of something is wrong. In other words, convince me so that we can have a strong debate or discussion on how a concept may or may not fit directly across the board. So going back to where the commission is here tonight, generally, I know one of the rules of thumb is public participation is huge when we look at the level of scrutiny as far as making changes to the county-wide ordinances. That's very essential. I think we all can generally agree, the more you hear from the public, the more helpful the policy is, whether we hear the yeses or the nos across the board. Public engagement is quite imperative, essential. For all the public hearings that we've had, we've done the statutory requirements of notifying the legal section in the Sioux City Journal, but we of course have added, the Danbury paper, the Mobile paper, Sergeant Bluff paper. Did I get to all four of them? Let's see. Okay, Journal, Mobile, Sergeant Bluff, and Danbury. Okay, so they've been notified each and every time of these public hearings. I think kind of in our recent past, we know that in particular, the wind and the solar have definitely rose up to a higher level. So I would have to say that the commission is kind of at a point where do you continue collecting further information on behalf of the supervisors to figure out where we're going to go potentially with this? Do you recommend based on the ordinance framework of what we've kind of identified? Does that entail that maybe we need to adjust this? And the reason is the definitions might be the biggest change, but technically if you add a larger zone, whether it's 5 or 10 miles, that's actually making the notification much more restrictive in that regard. But as far as definitions, that's offering further language to assist, but yet public input is definitely key. I think one of the concepts, I think Steve offers us a wealth of information about what the industry is across the board, but at the same time, it's essential the public knows kind of what's going on generally in their backyard and are a big part of the different policy changes across the board. So I would say that the commission can look at, either conducting more meetings or looking specifically to some of these really specific changes and talking to the Board of Supervisors about them, communicating with them. Again, this is just a recommendation body in the sense, and the supervisors ultimately will make a decision once a recommendation is sent over to them. They're in charge of conducting up to 3 public hearings as well and engaging the public on the higher level and in terms of maybe getting more media attention. Unfortunately, the supervisors do get more media attention than the commission as a whole. But in my time with the media, I've even had the privilege to tell reporters, you guys really need to come. You guys and gals need to come to the zoning commission more and report on where a lot of this respective activity does happen. So I guess I'll just kind of leave it with that. You've had a lot of material before you, and we've had public hearings where we haven't had some folks at. And the last one before this, we did have more in the room. The electrical union members were here last time as well. And we don't have as many tonight, which definitely surprises me. But with that said, I'll just kind of suggest you kind of ponder what I laid out in the packet under staff analysis in terms of those terms and definitions. But I do think that the commission has latitude to deliver to the supervisors how they see fit as a collective body on how you want to put a recommendation over to the 5 supervisors.
Commissioners, balls in your court.
Right now, it seems like, we've had quite a few public hearings now. Has it been 4 or 5? Since I'm relatively new to the commission.
Yeah, in your packet, we do have it defined on how many levels of discussion that we've had. And wish I could turn to the page perfectly.
But all in all, there hasn't been a tremendous amount of public feedback when you look at the county as a whole. Is that an accurate statement?
Yeah, I guess what I look at is we've used a very similar procedure with solar. We know the wind was a totally different thing, but we spent, I believe, I can remember this date very carefully. We started solar on September 11th that year. I think it would have been 23 into 24. And I think we wrapped up in April or close to April-ish there on solar. So we spent a lot of time. But during the course of that debate, you'll remember that we had a significant amount of farmers and property owners who were highly engaged on that. I think the distinguishing element of that, and I don't want to minimize nuclear by any means, but I do think that nuclear appears to be an industrial activity. And I don't think it's been shopped or sold in a way to have people believe that nuclear is going to be on a farm near you, but much more regarded in the industrial area. I don't know if that's an explanation why or why not. I think we got to be very, very careful with assumption, period. But at the same time, we all know how public policy works. The proactive policy is not so popular at times. We can bring up something, be proactive, but the minute you get an application or there's something where the heat is turned on, where here comes the project, then we get the more reaction to the specific policy. And I think that is a tremendous challenge when you're looking at the scope of something and the potential versus the fact that somebody filed an application. I think with the solar, the reason the hypothetical was different was I think that landowners and farmers, other folks heard things, received easements, received options, and we're talking about this where there was much more of a reality of something, and you're not seeing nuclear developers kind of run around the county and give landowners a sense of urgency that a specific policy is happening. We've worked within the ordinance as far as what the notification realm of this policy is. And I would have to say that Woodbury County is one of the most knowledgeable, engaged level of landowners that you can see across the state. They really care about their community. They care about their futures. And we've seen that firsthand, this room during the wind debate before the supervisors. You'd be amazed by that. You'd be amazed by the solar. I think since I've been here, the commission was more engaged on solar than any time ever. We had those work sessions. We had those things where people were really engaging. So I don't think it's a matter of the word not getting out. I've even thought, wow, do we start a infomercial or something telling folks that, hey, we're looking at nuclear here. Are we going to get folks out in that level? But I think when we're going back and just looking at, this is not a economic development play, it's a regulatory play in terms of, is the ordinance set up in a way that the public can agree upon for a potential project? We all know that when the ordinance was prepared back in 2008, it's a wide scope, broadly painted thing that's information overload, where you're dealing with about 6 or 7 pages of land use. And they very well could have put that in there at that time, and they didn't. There was some rationale, and I would probably have to ask some of our senior commissioners about the scope of what happened at that time, or what the rationale was about electrical energy generation, parentheses, not including wind. What is the intent behind that? Because if that was ever challenged at some point, they would be asking what the mindset of the county and the residents were at that time. And one thing that Joshua pointed out to me very well is we knew nuclear existed in 2008. Nuclear was out there. It existed. Because it existed, that's another form of challenge. Why didn't you put it in the ordinance versus why did you say general on it? And so that's, again, some food for thought. But there's the other argument about flexibility and the ability to look at the uniqueness of each and every project. So maybe some of the things that Steve has described could fit in that category. Then we're back to differences of opinion again. And then we're back to the concept of definition, specifics, stability. And that's where we're at with this juncture. And so it probably, depending on the expectations of the supervisors, are to look at this to see specifically how it could fit. And again, it's up to the commission on what kind of information you've discovered through a set time frame on what you want to deliver back to them as far as what the regulatory framework should be. And I can't emphasize this enough. We are planning and zoning. We're specific regulatory framework. The information Steve has brought is some information that helps us understand the industry, how things are changing over an X amount of time, and they have changed, and that would be part of the consideration. We haven't had a lot of public input, but today, and I would ask, I do have another comment that was submitted. We haven't got a lot of comments, but this one is actually a comment of opposition. It was submitted by Janet Kruger, and I would ask that the zoning commission make a motion second to receive this into the record because it wasn't able to go into the packet. But Janet Kruger, and I think that's how you pronounce it, and Randy Kruger basically said that we believe all levels of zoning in Woodbury County should expressly prohibit any nuclear-related activities, including nuclear waste disposal. That way, if any entity wants to perform nuclear-related activities in the county, they would need to propose zoning changes that allow the public to weigh in on a particular usage. We do not want nuclear-related activities to slip in before they are expressly prohibited in our zoning ordinances. Now, I do just want to mention that the comment was made about having a mechanism or a process. She mentioned rezoning or having a prohibition. That's kind of, in a sense, not trying to overly interpret, but it's being asked here that the public know what's going on, that there is a process in place of some form or another. But I would ask that this be received into the record so it could be included with the other comments.
I'll make a motion to receive.
Your second.
Second.
Who made
All
the
in favor,
motion?
say aye.
It has to be a
Oh, I'm sorry.
commissioner.
I'm sorry.
Yep.
Well, I'll make the motion then to receive it into record.
Okay, it's Steve Corey, motion, Hanson second.
Okay, all in favor, say aye.
Aye.
Thank you. All opposed, same sign. Okay, unanimous. Got it.
Okay, so I guess we could, one of two things, continue the public hearings. I would caution, we had talked about our agricultural community. We know there's going to be some planting going on. We know our agricultural community is now tied up again. And we always want them to have open access and open comment about everything. So you could have some more hearings on this in the future, or make some type of recommendation over to the supervisors based on where we're at now.
Personally, I think we probably heard everything we're going to hear. We've given, especially our ag community, the opportunity to speak, and they have not attended or spoken in either avenue. Again, that's my opinion. If somebody has an opposite opinion, let us know. Just to give you a little history and background on the zoning ordinance that we're talking about here. On page 13, it shows our existing ordinance. When we drafted that, we drafted it purposely to be vague. So you could put anything into that category that was actually energy generating. And pretty much the same for the chemical and gas bulk storage, because like Dan did say, we knew nuclear was here. We knew, well, this is not on the same level, but we knew wind was here. We knew solar was here. We had all of those things. But that conditional use gave us a flexibility to deal with each of those applications based on our standards. And that's why we left it vague. We don't want to tie the hands of any future boards or commissions or supervisors for that matter. And that's why we left it that way. I mean, but this took hours and hours and weeks and weeks and months of determining how we wanted to handle this. So that's what we came up with, something that's a little bit more vague and a little bit more flexible. Tom, jump in anytime because you had experience too.
Yeah, I agree with Chris. One thing I guess that was probably overlooked, or I would assume was not at the forefront of our thinking at that time, was the notification process of 500 feet with the nuclear facility, because of the fact that it impacts a lot larger area than that. And that would be the one thing I guess I would recommend that we figure out a way to address that, to make that a wider scope for notification process, because 500 feet for this type of facility isn't adequate notification. People are impacted beyond that. And just a question, Dan, you can go both ends of the spectrum. If this was a application that came before us and it went to the Board of Adjustment, the Board of Adjustment denied it, saying it doesn't fit under the category of electric generation, that party would still be able to argue that in court from that side of the fence. I mean, you can argue it from both sides where you get to. So, but Chris's comment regarding that it was purposely left vague, I agree with that comment, that was done. It wasn't to exclude it. It was to leave the window open for who knows what. And I think, like I said, the biggest thing I see right now is the fact that the notification somehow would need to be separate for nuclear than other electrical generation facilities, so that we could expand the notification area to encompass a larger area.
I want to add too that I think at the time we talked about, okay, if we added all these things to the terminology and the language that we have in our ordinances, are we inadvertently suggesting that we either promote or don't promote something? So we're trying to keep this as unbiased as possible too. I mean, I've heard a lot of information about nuclear lately, and too much of it seems to me to be crossing a line into economic development, and that's not what we're here for. I can't say that enough. We are here to listen to all the information, see if it fits within our ordinance, give people a chance, and let them help us make a decision that's right for the county. Okay? That's just paramount to what our purpose is here. Okay? Just any questions on that or any?
I would agree with the other statements, that I feel that the comments we've received so far in the multiple hearings that have been held, we're at a point now where I think I'm comfortable moving forward with identifying the regulations that go along with it and working with Joshua on his recommendation. I believe he has a very clear recommendation here for us to follow. So I'm comfortable moving forward to that next step.
Being a new kid on the block, and from what I've heard and listened to, and surprised that we haven't had more, the feedback has been, from what I've seen, more positive from the public than negative. There's nothing holding us back from, I agree that we need to do something here, and we could continue to have hearings until we run out of steam. But I think we have to figure something out on this topic.
So then my question goes back to, do we want to get so defined to add the language that's recommended by the attorney, or do we want to keep it flexible without identifying the need of putting nuclear in something that already covers our nuclear? We've got the bases covered. If he thinks we're going to be challenged in court, we could be, like Tom said, we could be challenged in court the other way too. So my biggest beef on everything is the notification. This, I think our emergency personnel had mentioned that this can impact up to 50 miles. We're not going to notify in 50 miles. It might be a little too aggressive, but I can understand 10 miles if there's another number somebody's thinking of.
If I may, kind of looking at the scenario before us here, obviously any next step is the county attorney's office in some form. I have some questions that I've gleaned off of you tonight that I have, and I want to say them to you and see if you think they're worthy of asking Joshua about. Now, Chris has referenced the flexibility. I fully understand that. But we've operated off of that a lot on different issues that have come up here. Now, Tom and Chris both alluded to the distance, the couple miles. Now, when you file the conditional use permit and we have electrical energy generation in there, do we tie the 5 or 10 miles, we'll say 10 miles, to the electrical energy generation? Or could we leave those categories a bit broad, but still put some definitions in the back of the ordinance? Well, because we have nothing in the back of the ordinance as far as what a nuclear energy facility is and nuclear waste storage. So would it be a reasonable question to ask Joshua if we could get definitions that kind of, in a sense, define or broadly point out nuclear in the definition, but we leave the table alone? And we leave it electrical energy generation, but if they're filing electrical energy generation, then we can flip to the back and have a definition to land on if they're in the scope of nuclear. Would that be something that we could retain the flexibility? Then we could point back to the definition and have the word terminology nuclear tied directly to the notification zone. So in a sense, try to keep the 500 feet in play for the flexibility, but yet by definition in the back. Now, definitions in the back are different. We don't have every single definition accounted for in the back up front either. Sometimes it's a reference point. So my question to Joshua would be, if the commission would allow for me to do it, not to kind of kick it down the road another month or so, but feel this out with Joshua and maybe bring back something from Joshua that has been filtered through us. I know sometimes the time frame is tough to get everything flushed out. And of course, we have the planting situation and everything, but would you consider affording myself and Joshua some time to maybe explore that as a potential ordinance language and then potentially bring it back? And technically, it would be highly recommended to do the public hearing thing again, just so that we have further dialogue. I just throw that out there.
I guess I'd respond to that. The comments that Joshua made to us regarding this, the argument is stronger anyhow on nuclear energy following under the electrical generation. So if there would be a way you could do that through the definitions in the back to tie the setback or the notification to that larger area specifically for nuclear, I think that'd be a really good step towards going in the right direction. Because like I said, I think under the electrical generation, nuclear was assumed to fall under that, but we missed the little caveat of the 500-foot setback or notification versus, and the 10 miles or whatever it comes up to. I guess I'd take some input, or I'd like a little bit of input from Michael Montino on that impact area.
Yeah, and I've seen the studies that have validated. I know Michael has mentioned in previous meeting, he's talked to us about both 5 and 10 miles and even 50 miles. I think he had referenced kind of in the past, and I've seen some studies. It's in one of the articles in the annotated bibliography in the packet, I believe. I'd have to find it, but that kind of references the plume area, or in the event, what is the further extended area as far as emergency response. And I think that could even go project at 10 or even more. And so notification, I think, is reasonable to try to include as many people as possible. And you look at the design of where we're at, we're a border state. Nebraska is going to care. Other counties are definitely going to care. I mean, as far as being able to be aware, awareness is everything. And also, just a disclosure, Joshua did kind of email me back today. I sent this latest language that was in the packet as far as having the definitions. He read it. He didn't see anything on the surface level that brought a huge red flag, but he always kind of references the fine-tooth comb where he wants to go through it further, and he's going to need some time to look at that. I think there are no other counties in Iowa that I could detect, if somebody wants to challenge me and point it out, please do, that has any form of nuclear written enumerated in their ordinance. And one of the things that we like, and I know the commissioners know this very well, we like to cheat off other people's homework. In other words, we like to get a definition that has been field tested and in other counties that has been upheld. And the definitions before you, and I kind of showed it a little bit in the packet there, were kind of pieced together through NRC definitions and federal definitions. There's just not a lot out there at the local level of defining nuclear energy, nuclear fission and fusion, and all the different nuances affiliated with it. So I would personally be more comfortable if Joshua saw the intent on how those definitions were crafted. And I would be curious to see what he would have to say about doing the best of both worlds, keeping the flexibility, but yet defining it in the back.
You good with that? Do you need a motion or no?
I think I would need to get some level of, I think the supervisors, I cannot speak for them. I'll get in trouble if I speak for them. But I will say that they've been very flexible with us on most all of our research projects, and I think we can all appreciate that. The level of time they gave us with solar, the level of time they're giving us on this issue. I know that we've paused for the agricultural community a few times, so I'll go ahead and add that in there just to say why we've extended out a little bit more. But we want to get this right, and we want to have the public informed about it. So what I would ask of you is to, I don't want to say the term bear with me, but allow me to work with Joshua on his schedule. Attorneys, you know, they can be busy at times, but it's a squeeze sometimes, even with a few weeks. But allow me in either April or May, preferably May because of the planting going on right now, that we can try to piece something together. And if I get it early, I'll do the typical contact you through the email and show you kind of what we've come up with for a while. But just so that you kind of have an idea of knowing what's coming up and getting into. But I think ideally it'd be nice to have that language, have it as proposed language in an ordinance, if people are generally comfortable. Run one more public hearing when it becomes available, and then see how the commission feels about it in order to ship it off to them as a formal recommendation.
Everybody good with that? I see nodding heads. That's
Yes.
good. Corey,
Yep.
your head's nodding, okay.
Could we summarize that into a motion?
Can you?
I would just say pending county attorney review, when it becomes available, return it to the zoning commission for a further public hearing.
Okay. We have a motion.
I'll make the motion.
Can I get a second?
Second.
All in favor, say aye.
Aye.
All in favor, opposed? Motion carries unanimously. There you go. Thank you, everyone, for participating and comments. Thank you, Steve, for bearing with us again.
Yes, ma'am.
Okay,
See you guys later.
thank you.
Uh,
We're going to move on to the other item on the agenda, which is dimensional size for single-family dwelling as follow-up for potential recommendation. This is an action item. Dan, do you want to read the information into the record for us, please?
Yeah, this here is meant to brief you all. I touched on it last month through information, but we had the public hearing to consider adjusting or lowering the threshold on the main body of a structure for single-family dwelling when it comes to manufactured or mobile homes. I had described to you kind of generally the intent on how that was used as far as the ordinance. And running it through county attorney's advice after Commissioner Hansen kind of mentioned, what could we do with adding on to the structure? Well, our ordinance, the way it was crafted, was very, let's say, well thought out as far as having the HUD regulations and the state code regulations. And what those state is manufactured and mobile homes technically have an aspect on them about they have to have numbers on them. They have to be certified. They're very specific. And what that means is the safety is brought into consideration when they're actually put together originally. And that's what the federal keeps in mind. So then they're brought to the site, they're mounted to the foundation, and they're meant to follow that specific HUD criteria. What Joshua did is he kind of went the extra mile and went into the federal code for us a bit, brought out a couple of those code sections, and it basically states in there that the manufacturers themselves have different types of additions or attachments that are affixed to the manufactured structure. Which means that they're certified and they fall under that level of compliance. They have to follow under the level of compliance. Sort of, you think of the structure comes directly from the feds under those rules, and they also would scrutinize the garage or the attachment. And what it kind of, I think the key way to describe it is a building code, they would talk about the shared weight load, the integrity of the structure having the shared weight load versus an independent level of weight load. And so what he looked at in terms of working with me on it is it could technically be expanded only if it met the federal and the state level. In other words, he said the county has to care about that. Typically, we've been trained to say, oh, it's a state code. There's a lot more freedom out there in the county. You guys all figure out about what the state code is. Joshua goes, not when it comes to the manufactured or the mobile home. So if somebody were to, and I know that diagram, Jeff and maybe Corey, we kind of discussed that at one point when you put the addition on and you increase the main structure and you go to 23, then you get to 23 with the certified attachment, then you basically fix it to the ground and everything. He feels that that would satisfy the legal requirement to be larger, only contingent that it goes under the federal regulation. It does not allow somebody to get some lumber and just start building their own thing. They've got to go follow their own rule and come to the conclusion and demonstrate how they meet the federal and the state code before something like that could commence. So there technically is a pathway for these property owners if they very specifically looked at it under that respective criteria. I did notify the property owners and had a discussion. I thought they were going to come this evening, but they are aware of what was kind of discussed here. And I had talked to Chair Chris, and we said, yeah, we were assigned a duty to look at this. And I had put in the packet that I think it's probably reasonable to report back to the supervisors that based on the low intensity of the public showing up, that we only had the two property owners, it's probably not necessary to make the change to the ordinance or drop that number or even touch that number for that matter, but to report back that this was vetted kind of through Joshua and there are the federal guidelines if people were to expand it into the main structure under the manufacturer's style certification. So I hope the packet kind of reflects what I'm saying here as far as, because I did run that back through Joshua, even how I communicated as well. And so I think that that's kind of a pathway to address that situation, but it does put the burden on the applicant to demonstrate specifically that they can get to that level. And that might even come to the point of what are the economics in it as far as the double wide versus the single wide versus the expansion versus proving that it can hold the single weight load as a whole as a unified structure. So
Are those specifications, those federal specifications spelled out clearly?
the federal, they're linked in there where it says 24 CFR, where it kind of talks about what an add-on is. And we've got the kind of the summary in there.
Okay.
But if somebody were to approach the office with a specific saying that, okay, we're going to do this and do this, we're going to slow down and we're going to have a conversation. And that's what we would try to do is identify that type of structure at the staff level and talk it out and point them to the places that they need to go as far as the Department of Public Safety at the state, as well as the HUD requirements for those. And when they're in a relationship and they're ordering them from the company, they can get pretty good clarification, I think, when they're talking about the add-on product. Any seller's going to love to sell the add-on product, so it's going to. So I would probably suggest that if I could kind of generally craft a letter together and maybe ask Chris to scrutinize that as chair, and if she's comfortable with that, then we convey something like that back over to the supervisors with, of course, Chris's scrutiny.
Everybody okay with that?
Yeah.
Yep.
Nodding. Corey, I can't see you. Yep. Okay, thank you. All right,
Okay, so
good luck.
So I guess I would say probably suggest just for the record, if we have a motion and a second to have no recommendation to change the number back based
Okay.
on this information
To maintain
Yeah,
what we have.
to
currently.
maintain the existing ordinance.
Okay,
I'd make the motion to recommend that to the supervisors that we make no changes.
Okay.
okay.
Second.
Motion and a second. Corey, that was you?
Yep.
Okay, all in favor, say aye.
Aye.
All opposed, same sign. That was a unanimous aye again.
Okay.
All right. Thank you very much. Next item on the agenda is item number 6, public comment on matters not on the agenda. No one on the phone, no one jumping up in the crowd. Okay, I'm going to say we have nothing from the public. Next item on the agenda then is staff update, informational item.
Okay, we got the Iowa State training coming up about zoning in Iowa. I believe, Don, was that the 22nd of April?
Okay.
Okay, strongly encouraged. Just please let us know if you plan on attending. It is on a Tuesday night. Yeah, it's on a Tuesday night, so we're hoping the Board of Supervisor meeting concludes early enough too, so that we can maximize participation from that realm as well. But my understanding is it's out at the Iowa State, the facility, the extension out
Okay.
there in Morningside this time.
Meals served?
I believe there was a meal, yeah. So,
Just checking.
yeah, that's an
Food.
important aspect. Usually the meal
Just meal.
increases attendance.
They're
But
usually very good.
yeah, so that's a big one. So please mark that on your calendars. But
Okay.
other than that, I can't think of anything at this point. So
All right. If that concludes staff update, we're going to move on to item number 8, which is commissioner comment or inquiry. Commissioners are remaining silent. Okay, going once, going twice, going 3 times. Okay, let's take a motion to adjourn.
Motion to adjourn.
Cory, okay, motion to adjourn.
I'll second.
Okay, we got a second? Okay. All in favor, say aye.
Aye.
All opposed, same sign. We are adjourned. Thank you, public, for being here tonight.